Hey, welcome back into the podcast today. Today, we're going to actually bust through one of the biggest myths out there for asset protection, which is you need to be a millionaire to have a trust. So, today we have a special guest. He's never been on. His name is Jason Morris. Jason, how you doing?
Good. Great to be here.
Thanks for coming in.
Thank you.
He works for Woodburn and Wedge,
Yes.
a local firm here in town that specializes. His specialty is in estate planning, probate, and trust law.
Yes.
And what he's going to do is we're going to walk through all what it takes to get a trust, why you should, pros and cons, and kind of answer any questions that are out there. So,
Yeah.
a little bit about yourself.
So I'm a local here, born and raised in Reno, Nevada. Attended Galena High School.
Oh wow, I did not know that.
Yeah, I went away to school at Brigham Young University in Utah. Did a joint degree program there with a master's in accounting and the law degree. And so, while I can talk tax, I don't necessarily focus on that, but it certainly helps in this realm of estate planning.
Yeah, so that's another good point is you need to bring in when you're doing a trust, you probably should bring in your accountant, correct? I mean, that's a important part of it.
Certainly for your overall, I'd say estate planning, that's helpful. On the trust piece specifically, typically that would be something that you would use the attorney to do that component, but definitely as part of your overall planning, we love having tax advisors, folks who specialize in that area.
Yep. So, all right, let's get started. Rapid fire. So first, we're going to talk about what is probate, because obviously, if you don't have a trust, something happens to you, goes to probate. So, what is probate, and why don't you want to go through it?
Well, selfishly as the attorney, I love probate because I'm the one who wins in probate, and so you don't want your family or heirs going through that process. But probate is essentially the court overseeing the transfer of title from a decedent to his or her heirs. And so the court comes in to assure that the rightful parties receive the assets.
So, great description. Yeah, so if something happens to you, essentially, the courts decide how to split up your assets according to what's out there, what documents are out there. Is that correct? That's a good summary.
Yes, yeah. The Nevada statutes or any state statutes will specify who receives your assets if you don't have any planning in place, and that will occur during the process of probate.
Okay. How do you prevent probate?
Yeah, the easiest way to prevent probate is the use of a revocable trust. Living trust, family trust, those are all synonymous terms, and that is the instrument or the tool that's most effective to avoid probate. Some people can get away with using beneficiary designations,
Okay.
but to be very holistic and cover all your bases, we prefer using a trust.
So, do you have any stats on what probate costs?
So probate ranges based on the size of your estate. I tell people kind of budget $5,000 as a minimum,
Wow.
all the way up to tens of thousands of dollars. A couple years ago, during the midst of the pandemic, we wrapped up a probate where my fees alone were almost $250,000, coupled with another attorney. And so that was an awful scenario where you were talking hundreds of thousands of probate fees. The estate lasted over 5 years. You don't want to be in that realm. No one wants that.
Yeah, so this is a perfect reason why to get. And I mean, 5,000 is on. That's really expensive compared to what a trust costs, and we'll get into the cost right now. So, tens of thousands of dollars, most likely, if you go to probate, and you aren't designated as the person where all your hard work goes to, where all the assets go. Correct. So
Exactly, yes.
so you don't need to be a millionaire to get a trust. So I see out there a lot. I have a lot of people that say, "Hey, I have a will. I don't need a trust." What is the difference, and do you need both?
Yes, yes. We see that common misconception that you think you can just have one and not the other. The reality is, if you have a will, that will must be probated. In fact, the very purpose of probate is to assure that the contents of a will are carried out and upheld. A will does not avoid probate. If you take nothing else away from this, I want you to understand that a will does not avoid probate. If you have a trust, you would still have a will as a backstop to your trust, but you really should have both. Even if you have a trust, you should have a will for purposes of assuring that no assets are missed or assets end up in the rightful party's hands.
Right, and we'll talk about that pour over wills in a second. But so then we're going to get down to it. a lot of my clients. What is the percentage? Do you have any idea out there? What is the percentage of in the United States on of people who have trusts versus don't?
Yeah, so the numbers for estate planning generally, and this it's not broken down by wills and trusts, unfortunately, but just any kind of planning is 33% of adults in the U.S. have some kind of planning, and I would estimate less than half that percentage have trusts, and so you're probably looking somewhere in the low teens of U.S. adults who have a trust in place, and again, if you don't have a trust and you have a will, you're still ending up in that pretty awful probate process.
Yeah. So good stat. In the teens, people have
Yes.
trust. It's insane, and you work hard your whole life. You deserve the right to designate where your assets go when something happens to you. Because at some point, we all meet our matchmaker. So,
Yes.
so who needs a trust?
I say anyone who has assets of $100,000 or more, it makes really good sense to have a trust. Because at that threshold of assets, you end up going through a more expensive, time consuming, public process of probate. So once your assets exceed that $100,000, and that can be equity in your home, that could be bank accounts, vehicles, small business interest, $100,000, you really need a trust. The other common scenarios we see are folks who have minor children. Do you want your minor children to receive your assets at age 18? It's very hard to know how an 18-year-old will handle assets, but generally we can assume not very well.
Right.
The final factor that we see is anyone who owns real estate in multiple states. So if you have real estate holdings in Nevada and elsewhere, a trust is very practical, because if you don't have a trust, you would face probate in each of those states where you have real estate holdings.
Yeah. So if you own real estate, probably median home price in Washington County is 500,000. So you're over the 100,000.
Yes.
Most likely, at least half the people are above that number and half the people below. So, all right. So a few specifics. I'm not an attorney, but I just kind of want to talk about if they come into an attorney like yourself. What are the top 5 to 7 documents that are in what makes up a trust, so people know?
Yeah, great question. A lot of people come in saying they know they need a trust, and then they think there's nothing else. So if you have a trust, you would still have a will, and we call that a pour over will. In addition, we prepare powers of attorney for both financial and healthcare purposes. At our law firm, we also help you fund the trust, or we help you transfer title of your assets into the trust name. The trust is just paper, and that document is not worth the paper it's printed on unless you have your assets titled and transferred into the trust ownership. And so we will help with that process. There are numerous types of transfer instruments that can be part of your plan. It just varies depending upon each individual's asset holdings.
Okay, great. And what's the time frame? So if someone, I get a lot of people who want to try and put it off, and they're like, it takes too long. So it's too complicated. What is the process? So if someone calls you, what does it look like on setting it up and from start to finish, typically?
Yeah, so this is one where we push back on the clients and say, the ball is in your court. We can typically turn around draft estate planning documents within a couple weeks or less. We need information from the clients. We need personal data, who they are, if they have children, married, and then importantly, we need their asset information. So we need copies of account statements, deeds to real estate, information about their small businesses. Once we have that information, we strive for less than a 2-week turnaround time.
Wow. Okay. So it's up to the client to do their homework, and I'm guessing that you give them a sheet.
Yes.
And they step through all the stuff they need to provide you.
Exactly. We have a checklist of asset information, and then a 4-page personal data form to gather information about who they want involved and where they want their assets to go in terms of a plan of distribution.
Okay. Now I see some people who start trusts and don't fund it. So what does it mean to fund your trust? A very important thing to remember out there.
Yes, funding the trust is crucial. I can have the most magnificent trust on Italian linen that's, in and of itself may have some value, but the real value is actually changing ownership of your assets. Jason Morris should have few, if any, assets owned in my individual name. Rather, they should be owned in the name of the trust. And that means taking a deed and changing the deed with real estate into the name of the trust, taking bank, checking, savings, brokerage accounts, moving those into the name of the trust. This can all be done with some devoted effort in about half a day for most clients. Some individuals have more complex assets and it can take a little more involvement, but the reality is funding the trust is of utmost importance because otherwise the trust terms are not valid.
Right, kind of worthless. So, something that caught my attention. You said Jason Morse shouldn't own too many assets outside the trust. What are the few examples of assets that should not go into your trust?
Great question. The most common answer there are retirement accounts. So IRAs, 401ks, 403bs. You could go down all the acronyms and numbered sections of the Internal Revenue Code. But retirement assets generally are not owned in the trust because the government wants to know when they can start taxing people. And taxing people by virtue of the RMDs, or required minimum distributions. So those retirement assets must be beneficiary designated, or we must update the beneficiary designations in lieu of changing the ownership into the trust.
Okay, and then what about, this is kind of just off the cuss question for you. What about vehicles? Because I heard from some attorneys you should put them in there, you shouldn't. What's your opinion?
Yes, so we typically do a separate writing for our clients that's not part of the title to the vehicles, whereby we state that the clients intend for their vehicles to be part of the trust rather than make them go to DMV and change title. That way, we're doing an end around and we hope to avoid probate if or when that client dies, that we have some writing indicating their intent to have those vehicles as part of the trust.
Great. And then what happens if there's something, I've dealt with trust just from a real estate point of view where something wasn't funded in the trust? Or is there an instrument in a trust that allows you to get that in there if it was forgotten or not funded?
Unfortunately, the process to transfer assets into the trust after someone has died is a form of probate. Nevada has actually loosened up our statutes to allow for an expedited form of probate if a client has a companion pour over will with their trust. So we can go through an expedited form of probate by having the pour over will coupled with the trust.
Okay, pour over will. Okay, so that allows you to, if you forgot an account, has a couple $1,000s in it, allows you to pour it into the trust. So,
yes.
And there's a lot more into these things. Then that's why you got to come talk to the experts. We're just going high level. Now we're going to talk some real estate because obviously this is a real estate podcast. What is the process? Let's just say there's two different examples. Like you're going to buy a house. Can you buy a house, put in your name, and then have it transferred into your trust? Or is it better to get a trust and then buy a house? Or can you do both?
Yeah, the latter. Or you can certainly do both. Preferably, you would acquire the home in the name of your trust if you have a trust prior to the purchase of a home. Having said that, we help clients all the time who have a home already. We put the trust in place and we can very readily transfer title and move that primary residence into the trust ownership.
Okay, and the interesting part is we just had someone that had a trust in place, and I think the title companies want to see your trust certificate,
Yes.
and then it's a one-page. You don't ever have to. I would push back on anybody that ever wants a full copy of your trust, especially in a real estate transaction, correct?
Yes.
You can always turn over what is in the front called a trust certificate, correct?
Yes.
What is a trust certificate? Because some titles are like, oh, we need to see the full trust. And I'm like, no, let's just give the trust certificate. It should be enough. Is that correct?
That is correct. No one really needs to see the whole trust instrument unless that is your successor trustee who is trying to execute the trust agreement. For real estate transactions like acquiring a primary residence or even a rental property, you can use a certificate of trust, which is typically a 1 or 2 page form that gives the highlights or salient provisions of the trust, thereby avoiding the need to share the entire private or confidential instrument with that real estate company.
Yeah, be careful of that because I see a lot of people asking for it, and I don't necessarily think, at least in Nevada, and I'm not an attorney, I would talk to your attorney before you would give over your trust because there's a lot of information. That's the one advantage, correct, of having a trust. Probate's all public information, right? You get to see all your assets and it's open for public display, correct?
Absolutely. Probate is a public process. So anytime a celebrity dies and their will is lodged with a court, that's available online within minutes. And so probate is a very public process. Everything must be filed out there in the world. So to the extent you want to keep your affairs private, your asset details just within the family, trust is definitely the answer.
Okay. Okay, now we're gonna get down to the nitty gritty, because we're gonna have people now that say, "Wow, I don't need to be a millionaire. I have a house that's 600,000. Might need to get in and talk to Jason about getting a trust." What is the cost? Because people have this. Oh, it's so expensive. But you just said probate. The cheap probates cost $5,000, and I'm not trying to. I know there's inflation, but approximately, can you give? Obviously, if there's a really complex, it's more. But generally speaking, what's the range for to start up a trust? Get it?
Yeah. So typically our fees are around $3,000. Certainly we have some less than that. Certainly we have some more than that. I would say 3,000 is kind of the sweet spot for a full trust planning package, which would include the trust, will, powers of attorney, and the funding instruments in helping you transfer title of your assets into the trust. We're doing a lot of work for Californians who have relocated to Nevada,
Yeah, great point.
and we are updating their instruments. A lot of times that's closer to the $2,000 range when we're doing an update, because we're not having to do as many of the funding transfers. But for this amount of money paid during the life, you're going to save thousands
Yeah.
and a ton of time after death.
Well, I mean, even if you have the basic, you're saving $2,000. What's happened, and then you get to make sure that you get to determine what happens to your assets. I think that's and your kids and all that stuff. So,
Exactly.
so we're trying to bust through this myth. Only millionaires need trusts. Why do most people not want to get a trust? I mean, is it because they are afraid to talk about death, or what is the reason?
Yeah, so there's surveys that have broken this down, and 40% of people simply say that they just haven't gotten around to it. So it's like most things in life that we procrastinate or push off. So the biggest factor that we see by survey data is people just don't get around to it. The next largest factor is people just feel like they don't have enough assets. They don't justify, excuse me, with the millions of dollars, and that's just not true. There's really not a need to have millions of dollars. Rather, we're talking closer to that $100,000 range.
Right.
A couple other factors is people feel like it may be too costly, and then also they just don't know how. They don't know where to go, which attorney to go to, and so we are here to be a resource for folks who need that assistance, and we feel that our costs are right in the typical ballpark for what you pay to get this full planning package.
Yeah, and shop around. Obviously, I mean that we do that with realtors. You do that with anybody. Shop around, talk to some people, and then get in there and get it done. So, all right. So we found out why people don't do it. When someone has a trust, so a lot of people I know because our clients were talking to you and others. If they have a trust, how often should they get it reviewed? And is there a particular event that happens in some lives that would cause someone to want to get it reviewed?
Yes, definitely. So we say the common times to review or update your plan would be the salient life events such as birth, death, divorce, marriage, or a change in financial circumstances. So if any of those factors apply to you or any of the individuals you've named in your trust or estate plan, those would be opportune times to revisit your planning. The other factor that we can't control would be tax law changes. If Congress is good for nothing, they're good for changing the tax law and tax code. And so every couple of years, it seems like the laws are being upended and revised. And so that also would beg for a time to revisit your plan, particularly if you have a taxable estate, meaning millions of dollars.
Yeah. So get that checked out. So, all right. Well, thanks for coming in. Anything else out there that you would, any more last minute advice on trusts?
I would just tell you, like Ken said, please shop around, ask for referrals, ask for who your friends, family have used, and go to someone who specializes in this area. Much like I don't pretend to do criminal law work, the person who maybe helped get you out of your DUI, they probably shouldn't be the one to do your trust.
Right.
Or the person who helped get you out of your divorce, probably not the right fit to do your trust. And so I'd really encourage you to find someone who focuses and specializes in estate planning. you're going to get a better product. And I think the old adage of you get what you pay for applies here as much as ever.
Right, great. Well, great advice. Get in and get a trust. Most people in the United States are over 100,000. If you own a real estate, you're playing with fire. If you have kids, it's just important. And the only reason I even brought this interview in and want to bring it to the attention of our clients out there is I deal with a lot of trust companies that manage people's trust, and it makes things a lot smoother, and it makes it easy to get rid of your assets and disperse them how you want it. We see cases all the time that people don't have everything in place, and it's a complete disaster, and it makes it really tough, particularly on your family if it's not in place. So it's particularly if you have kids. So thanks for coming in. We'll have you back in. Call Jason. What's the best way to get a hold of you? We'll put it down in the link in bio, but what's the best way to get a hold of you?
Yeah, our main office line is 775-688-3000, and that's an easy way to track me down.
All right, great. Well, like our videos, we're going to have Jason again talk about LLCs. That's another thing. Asset protection is kind of our MO right now. We're making sure that all of our clients have the best knowledge and work with the best people to make sure that their assets are protection. So until next time, you guys keep liking our videos. Give us a thumbs up. You can always reach us through the messages or leave comments on our videos, and we're always responding. Until next time, you guys take care, and we'll talk to you soon. Thanks.